With the advances of the internet and various new software programs that are out there that help you do your own income tax returns, business formation, a lot of people have turned to drafting their own wills and estate planning documents as well. And as attorneys, we often cringe or get nervous when we hear people drafting their own wills or estate documents because there's a lot of room for various different types of errors and issues that can arise from incorrect drafting. Well, there's a lot of different issues that can come up. The three main errors that we're going to discuss today with DIY wills is incorrect use of language, state-specific execution requirements, and tax considerations. These are all big mistakes that can come up when doing your own will without the assistance or advice of a professional attorney who practices in the area of wills. When we talk about state-specific execution requirements, we're mostly talking about whether the person properly signed their will at the bottom of the will in front of the appropriate amount of witnesses. Many states differ with regard to how many witnesses you need in order to validly execute your will, but most states, including Pennsylvania, require 2 witnesses at the time of your will signing. What this means is those 2 people have to be disinterested individuals who are simultaneously in the room with you watching you sign your will. So this means that the person who you named as one of the beneficiaries in your will probably should not be one of your witnesses because it can open up your will to a contest. Also, they must be simultaneously in the room with you. So you cannot, for example, go to a neighbor or a friend and sign your will in front of them, and then afterwards go to another person and have them sign your will as a witness after you've already signed. They must be in front of you at the time of your signing at the same time. If you have your will done by an attorney, these requirements can be properly vetted, and they will also have a self-proving affidavit attached to your will, which the witnesses will sign, which states that they are disinterested individuals who watched you voluntarily sign your will and that you are of age and were not coerced by anyone to complete your will. This saves time at the time of the probate of your will so that these disinterested witnesses do not need to be located so that they can vouch for the fact that they were present and watched you sign your will. Another major issue with regard to drafting your own will is the use of incorrect language. What this often refers to is precatory language, or language that refers to your preference or your wishes, but not any unambiguous intent to dispose of your assets. In order to properly dispose of your assets or a portion of your estate, you cannot use language such as "I wish" or "I would like." You must be clear and unambiguous with who is getting your property and where it is going. So a bequest that sounds something like "I wish to give $5,000 to my niece if she graduates college" is not a proper bequest to your niece. It must state "I give to my niece $5,000. Another big issue with regard to incorrect or issues that come up with improper drafting of wills is tax considerations. If the net value of your total estate is large enough to kick in the estate taxes on the federal level, you may need an estate attorney to help you properly plan for how to dispose of your estate and how to possibly save on those taxes. Further, many states such as Pennsylvania have inheritance taxes, and in order to properly apportion those taxes amongst beneficiaries or save on those taxes, you should have an attorney present as well to help you correctly indicate who should pay what tax and from what portion of your estate that tax should come from as well. Without having an attorney or a professional who deals with estate planning or will drafting help you with drafting of your will, you may end up, or your will will be open to a contest, which may end up in court with a judge or a jury having to decide what your intent was with regard to the disposition of your assets. The result may end up being something that is totally out of line with what you intended to do or how you intended to dispose of your estate. And it will cost your loved ones or your estate a large amount of legal fees as well as court costs. which may end up being more than what you intended to save by drafting your own will instead of having a professional do it for you.